Hello and welcome to our video on hybrid mediation. I will start off with some introductions before we get started with our discussion today. So those of you that don't know me, my name is Laura Clapton of Mediation. I run the practice which I set up 7 years ago now. I am a family solicitor and have been for just over 10 years, and I've been a practicing mediator for 8 years. I am qualified to speak to children as part of the mediation process as a direct child consultant, and more recently I am a qualified hybrid mediator. And I'm joined today by Melanie Hartley, and I'll let Mel introduce herself.
Hi everyone, I'm Melanie Hartley. I'm a consultant solicitor, or very newly a consultant solicitor with effect from January. So for those of you that don't know what that is, I'm classed as self-employed, but I'm actually working with 2 firms at the moment, Rookledge Law and also Foster Clare. I've had experience of working with the hybrid mediation session with Laura, so we wanted to just jump on today and just explain what we think about the process and what the benefits are, and some drawbacks, and just highlight them from a solicitor's perspective, because for me, I had absolutely no idea about the hybrid mediation process until I was involved in it. I suspect that a lot of other solicitors are the same, so we just wanted to be quite informative, but in an informal way, didn't we, Laura, just to explain a bit more about the process.
We did. Mel and I have known each other for many, many years now, right from the start of our careers. So yeah, we wanted this to just be a really informal chat. Mel and I haven't had this conversation actually since we did work together on a hybrid mediation. So I'm actually really eager to understand sort of Mel's perspective as the solicitor involved in that, and I'll share with her from my perspective as a mediator, and hopefully you'll find it useful, not too dry. And we're doing it in conjunction with Family Mediation Week as well. So obviously this week is all about promoting family mediation and the different models that are available. And the more that we can share about the different models and how creative you can be within mediation, it's not one size fits all. So hybrid mediation is just one model that we want to explore today. And as I say, hopefully you'll find it useful. So I'll start off. So I think probably the best place to start then is for me to just explain a little bit about how it differs from the traditional mediation model. So traditionally, with a family mediation, you've got the family mediator, the 2 participants, to the 2 clients to the mediation, and you will either be round a table or you'll conduct what's called a shuttle mediation, where you've got the 2 participants in different rooms, and as the mediator, I will go back and forth between those rooms, relaying to each other what has been said. Now, the hybrid mediation model differs in the way that in a hybrid mediation, I can have separate private meetings with each client, with each participant's mediation, and I can hold confidences in those meetings. So rather than having to reiterate everything that each party has said, if by way of a shuttle mediation, or to be completely open with each other around the table, what hybrid mediation allows me to do is have separate confidential meetings with each party and to agree during those discussions what is then fed back to the other person. So it's an opportunity for each party to be completely comfortable with sharing their views to the mediator, knowing that they can then agree with the mediator what's then fed back to the other person. In addition to that, a hybrid mediation model often involves not only the clients, but also their lawyers. And that's obviously where Melanie came in the case that we dealt with together. So in that scenario, as the mediator, I'm going between 2 rooms or 2 virtual rooms where you have each party and their legal representative in their individual rooms. And I can have private discussions with each party and their lawyers, and collectively we agree on what is then fed back to the other party and to their solicitor. So the 2 main themes that you'll see with a hybrid mediation is, first of all, being able to hold these confidences for the mediator, so not having to reiterates everything that's been discussed to the other party, so that you can agree upon what's relevant, what's important, and formulate those proposals in a private space with the mediator. And the second aspect of it is that lawyers are often involved, not always, but in the main, lawyers will be involved in that mediation, hybrid mediation process, so that they can support and advise their clients throughout the session.
Mm-hmm. Yeah.
So, I mean, did any of that for you, Mel? Were you aware of any of that before before it was suggested that on this particular case that we dealt with, that hybrid mediation might be appropriate?
Until I got the instruction to deal with it, no. And I'll be honest, when I was approached to deal with it as a hybrid mediation case, I did think, oh my God, you know, what's my role going to be, and how is this gonna work out? And I think that was my only initial hesitation, if I can put it like that. But then when I had a conversation with you, so for people who don't know, well, I'm guessing that you would do this as standard law and that other mediators would, but you had a conference call with me and the other solicitor who was representing the other party, and you set out what our role was and what our involvement was to some extent, and kind of what the ground rules are, if I can put it like that. So until we had that conversation, I didn't really know that much about it. But after having that conversation with you, I was obviously raring to go. But then even still during the mediation session, it was a case of, well, given that it was my first one, I was still kind of taking your lead massively in terms of how you were conducting the session. I was very much aware that this was your mediation session with the parties, and that the solicitors were there as an advisory capacity for their clients only, and that actually helped a great deal, because I mean, I don't know what other people's experiences are, but I've done plenty of roundtable meetings before. And, you know, I'm probably not alone in saying I'm not a mediator. I've never been collaboratively trained either. So when I've done roundtable meetings, it's just a thing of getting in with another solicitor and your clients and just seeing what you can narrow in terms of issues, and then having breakout rooms if you need them. But it can be quite off-putting doing that, because you don't know how the other solicitor is going to be, and you don't just want it to be lawyer at lawyer. And I know a lot of us are not like that, but you know, there are some people that, you know, would construct a roundtable meeting in that way. So for me, this hybrid process was so good, because it just, you were chairing the meeting, it was your session, and we were there to support. So there was nothing else expected of us other than that. So I did learn a lot during the session as well.
Yeah, no, that's great. And just to answer your question at the beginning about those initial conferences with the lawyers, I mean, that's something I do in every hybrid mediation. And I suspect that most mediators would do the same, but I agree. I think it's such an important meeting to kind of set out those ground rules, and just important for lawyers to understand what their roles are, because many lawyers who come to the hybrid mediation process, and in fact, every single lawyer that I've dealt with so far, it's actually their first ever hybrid, so they're not entirely sure what to expect. And although they're professionals, similar to clients, and we're all human, we can all get a little bit anxious about a process that we've not been involved in before, because we don't know exactly the structure, what our role is, and how it's going to be, you know, how it's going to progress. So I think it's really important for the lawyers to help understand that. So in that session, I like to explain practical things like the structure of it. So for example, in this case that Mel and I dealt with, it was to be dealt with online, and actually I made it clear that although we'd start off together on one screen, I'd put them into separate virtual breakout rooms, and I'd go between, and perhaps we'd come back together if it felt appropriate, or otherwise, you know, we'd continue separately, and just sort of to give them a flavour, explain time frames, and really the key thing really is explaining their role, because as Mel said, they're there in an advisory role, but in a supportive role as well. So what I don't want the lawyers to do is take it away from the clients, because it's the client's process as well. It's my process as a mediator, but it's also the client's process. And the beauty of mediation is it's about empowering people and making them feel that they're in control of their own process and their separation. So it's just really important for the lawyers to understand that. And then finally, I think what's great about having that initial meeting is having both lawyers together and me sharing this information to them. And actually what I found is at the end of that meeting, collectively, it's really felt like we're a team working together to try and help those individuals come to a resolution. So, you know, although each lawyer's there to act in their individual client's best interest, there's a real coming together to say, actually, you know, we're all committed to making this process work.
Yeah, totally. And I was really, I mean, I didn't doubt the process before I got into it. I knew it was going to be a really, really good concept. As soon as you explained it to me, I was really hopeful, especially on the case that we were on, that we'd have a successful meeting, and we did. And it made me come away from that process just thinking, this is it, this is, for the right case, this is the way in which we should be really dealing with issues, because the amount of time we must have saved on backwards and forwards in negotiation. So if it had been a normal mediation session without us there, you'd have probably said to the parties, go and seek legal advice. The client would have come back to me, got booked in, had some advice, but then I don't know what the other party's position is or where they're coming from with it. So it's kind of like one-sided advice to some extent. So there would have been backwards and forwards, and you know, I imagine the process could take even longer, but what we did, we sat down and bottomed it. And I found really useful hearing what the other person's position was, because we often do hear that when we're reading a letter, don't we? But a lot of it gets lost in translation, and when it's filtered through a lawyers, we with the best will in the world, we had our own spin on things, and the message can get diluted. But when you're actually there in the meeting, yes, obviously in our session, the other party wasn't there for us to see and be involved in that discussion, but you were able to feed back all the relevant information and the rationale behind it, as opposed to in terms of where they were coming from, which then helped me guide my client into a settlement. So I just thought it was a really, really good process, and one that I am actively suggesting on many of my cases.
Yeah, and I think that's right, Mel, in terms of you know, things getting lost in translation, and you know, the correspondence that can go between solicitors, and you know, ultimately it's not neutral, is it? No. You know, it's correspondence on behalf of your client, and as a mediator, what I try and do is neutralise the proposals, the comments, and also present them in a way where I think that it has the best chance of being heard and being understood. Because the key thing about mediation, whether you're doing hybrid or traditional, is trying to get the other person, both parties, to see things from the other person's perspective, because there are always two perspectives, there are always two narratives, and it's just trying to present that in a way that is going to be conducive to actually encouraging further negotiation and ultimately leading to a settlement. Is there anything that you didn't expect from the hybrid that you saw throughout the process after we'd sort of had that initial meeting?
No, but perhaps it was because ours was a successful one. I was very, very impressed at how you were able to neutralise the comments, and you know, that definitely helped, and because of that I were able to have a more neutral conversation with my clients. So I think it just definitely helped to keep things on an even keel, whereas obviously when you're dealing with correspondence and it's written in a certain way, or when you're at court and you hear submissions that are presented in a certain way, it just heightens the emotion and the tension. So I think that was a major part of the success in this case. So there wasn't anything I was kind of shocked or surprised about, but I think that I mean, there must be some careful selection of, you know, whether a case is appropriate for that kind of session, because I imagine that depending on who the lawyer is on the other side, or depending on the parties' positions or what the issues are between them, I imagine that you might assess a case for not being suitable. Am I right?
Yeah, absolutely. So not all cases are suitable for the hybrid model. Interestingly, there are a lot more cases that are suitable to hybrid than cases that are suitable for traditional, and I'll kind of explain that a little bit more. But yeah, absolutely. With hybrid, you need both, first of all, both parties and both lawyers need to be committed to that process, because what you don't want to happen is either lawyer come in and unravel what you've already been able to achieve with the parties, or take over the process. So there has to be that's why those ground rules are so important. And so yeah, absolutely, there needs to be full engagement from everybody involved. And ultimately, I don't always recommend it as the first avenue either. So for example, in a case where we're dealing with children issues, so obviously in our case it's finance, but involving a case in relation to children issues, I would encourage initially the parties, if appropriate, to come together, just them as parents and me as the mediator, and to start having those conversations without necessarily feeling the need to bring the lawyers in at that point, because as much as I can neutralise and the lawyers can engage, it can quite quickly still feel like a very positional model to be in, where you've got lawyers there, that there's a need for lawyers there. And actually, a lot of the time in mediation regarding children issues, we're talking about co-parenting, we're talking about behaviours, we're talking about communication. We're not talking about legal issues. And where hybrid mediation works really well is when there are legal issues and maybe you've reached an impasse, and maybe each party have got a very different view on a particular legal issue. Let's say it's something regarding inheritance, for example. And actually, as a mediator, although I'm a lawyer, as a mediator, there's only so far I can go in informing the parties as to the relevance of a particular legal principle. And sometimes actually it's really helpful to have the lawyers there who then can give that advice to their clients about that particular issue there and then. But also the lawyers have to, in some ways, they're sort of having to justify their advice as well in their positions, because they're not just giving that advice to their client, but they're also informing me as the mediator that that's their viewpoint on that particular issue, knowing that I'm going to be speaking to the other lawyer, sharing their viewpoint, and seeing what seeing what the other representative's viewpoint is on that particular issue, and also knowing that I'm a solicitor as well. So it's not, then it's a different dynamics, and I think then that also helps, much more than having a round table where actually you don't have to justify your position to either, you simply argue the point, whereas actually having the mediator there and that neutral person, I think really does help as well in the lawyers just ensuring that they really do stand by that advice, and that is true to where they see the fairness in the case lying. So yeah, places where it works really well, I would say, where you've got complex finance issues, and again, maybe we just need the lawyers there as well, so that rather than having to keep saying to the clients, okay, well, after this session, go get the advice, come back, after the session, go get the advice, come back, and leading to multiple sessions and then additional cost, time, delay, etc. That actually having us all there, and then really good for getting over those maybe complex legal issues, where we might want to instruct experts, so if we're going to need a pension report, again, there can be a little bit of a disconnect in mediation. When you then need to get a pension report, who's drafting the letter of instruction, what goes into the letter of instruction, the mediator can't draft the letter of instruction, but then do you just trust that the clients will go back to their lawyers, not trust, but do you leave the clients to their own devices to go back to the lawyers and say what they need, or actually just get the lawyers involved and we agree it there and then together? So it can be really good for that. It can be good where there are safeguarding concerns and actually the clients themselves without lawyers and round a table is just not appropriate. There might be domestic abuse concerns, for example. Actually, a hybrid works well. One, because you've got them separate, first of all, so they're not having to see each other, but more than that, they've got the support of their lawyers. And if they're a particularly vulnerable client, that might be absolutely what they need in order to engage in mediation. So what I was saying before about actually more cases are suitable for hybrid than traditional, it's because cases involving vulnerability, high conflict, we hear the term narcissistic personality, those types of cases are better for the hybrid model. So there's a real big scope for cases where hybrid can work really well. Now, obviously, we both know that does involve an additional cost because you've got the lawyers and the mediators, and that has to be a consideration. So I wouldn't necessarily say in every case, just bring the lawyers along, we'll do it hybrid. But for a number of cases, it can be really, really beneficial at just unlocking that impasse, as I say, that clients have gotten to, where they just can't move forward without the lawyers there.
Yeah, completely agree. I can see benefits to doing it on loads of cases, to be honest. You've obviously got to have the buy-in, haven't you, from the client to go down a mediation route, especially if they've got in their mind that they wanted to litigate on it. But one thing I've been saying to clients is obviously the delay with the courts issuing applications and things like that. You know, I've been actively promoting this as a method of dispute resolution that we should be considering as a matter of course. You know, we make mediation referrals, don't we, prior to issuing court proceedings, and I think just that steer from solicitors on the positivity of hybrid mediation as an alternative should be something that we all think about, and just try and alleviate some pressure from the court. I know there's other things that people can think about as well, like arbitration and things, but you know, that's an expensive route as well. And I just think that if we are considering, you know, a lot of people have got contacts and relationships with mediators, and it should be something that us as lawyers are really giving full consideration to. But it's just about getting that message out there, isn't it, and letting people know that there is this process and it can work well, and you know, getting everyone to think about it.
Yeah, and it's not, you know, it's not a scary process. It's not something that's reinventing the wheel. It's very similar to what we do as lawyers as well, you know, day to day, whether it's, you know, doing a round table or referring to traditional mediation. But, you know, there will be some, so for example, you might have a case where you've done the financial disclosure, exchanged Form E's, schedules of disclosure, whatever, and it is getting to that point of moving towards proposals or decide on experts or whatever, and it just might be you get to a stage where you think, okay, got a couple of options here. We either, you know, just try and thrash it out in correspondence. We either do a round table. How comfortable are we with that? And depending on who the solicitor is and the relationship, or do we do a hybrid where we are getting around the table? We're not sending letters back and forth in correspondence, but we've got somebody, like you said earlier, Mel, to chair the meeting. You know, we've got a neutral chair there, and actually the cost of having that mediator there, if we were going to do a round table anyway, having that additional cost of the mediator, which is in the hundreds and not thousands, actually is that a really good use of money and time to give this meeting the best possible chance of success. So, you know, it doesn't have to necessarily start out with the mediation and bring the lawyers in. It can start out with the lawyers and then move to a mediation. So it's a really flexible model.
Yeah, and that's how I saw it as well. And, you know, the feedback that I had from my client when I was doing this hybrid mediation process was so positive, and it would just as well that it was a long session. And I imagine I was going to say to you, actually, is that a standard thing? Because I imagine that hybrid sessions are quite long.
So in my experience so far, they've been at least 3 hours, but I would say realistically, the mediators, the clients, the lawyers need to really block out half a day for a hybrid. I mean, you could even, on certain cases, because again, it's a flexible process, you might even want a full day. I mean, it's not that dissimilar to the civil model. You know, if you have a mediator, the civil mediator doing a talata or something like that, they will generally book it out for the full day. And whereas in family, we tend to do shorter, multiple sessions. I think it just depends on where you're at in the process, what the issues are. But I'd say a minimum of sort of 3 hours, preferably half a day, but could go on a full day. Issues.
I would completely agree with that. And the advice that I would give to my client about the duration and, you know, what is expected of them and how involved it is, because if you're on a roll, you don't want it to end. It's like being at an FDR and you're like, you know, we're nearly there, let's just keep going, let's try and bottom it. And you can spend all day on it, you know, if it's successful. I suppose if it won't going well, then you just know pretty early on, and you know, you can call it a day. But I think blocking that amount of time out is good. And it just, although we were obviously in like a virtual waiting room and you were going back and forth, so your role is very much constant, ours from a solicitor's point of view isn't. So when you were going in between the rooms and it was just me and my client in a room, you know, we'd be talking about the position and, you know, the legal side of things, and I would be giving him the advice. But then while we were waiting, we were just having general chit chat about all kinds. And I think that really helped as well, because you can simmer the situation down and they're not just sat there waiting and wondering and thinking, you know, what's going on, or, you know, the tensions can mount. So you're able just to try and, again, keep it under wraps a little bit and just try and distract them in any way. So I thought that was quite useful as well. I imagine, though, that it's just a lot more hard work for you.
Yeah, I mean, as the mediator, and that's it, you know, because it is done in that kind of shuttle model where you're in different rooms, you're only seeing half of the session, you know, in a lot of ways. And so for the mediator, yeah, absolutely, it's, you know, it's that constant. But I think that's such a good point, Mel, about just the clients having that time to just reflect, think, consider, but also to have you there to just help them relax into the process and into the session. And they're not sat there, as I say, wondering. And I think that it really did. And I felt, I mean, I definitely saw, in terms of client, I have seen in client behaviours in a hybrid mediation, I've definitely seen a difference between that and in a traditional model where you might be going back and forth and they're sat there on their own. I just think that like sense of anxiety might not be as strong when you're there with, you know, the support of your lawyer. And I mean, in our particular example, you know, you and both you and the other solicitor involved, you were so good at allowing your clients to really own that process. And I think that's another thing that's really important. You know, you weren't trying to speak for them, you weren't cutting them off, you were allowing them to speak openly, knowing obviously that it's a safe space for us to have that conversation between the three of us. And again, it just ensures that they still feel like they're in control and feel empowered. But then they also feel empowered to say, actually, Laura, would you mind just stepping away for a moment? Because I'd like to just speak to Mel privately. And that's the beauty of it as well. And I'm glad that they felt comfortable to say that to me, because that's really important, that they could feel, actually, I just want some private time with my lawyer. And that's really important as well. So, you know, that's when I step out and sort of give that time. That is actually the only time when I'm not doing anything. When I'm waiting to be called back in.
I can imagine. Yeah, I definitely felt like I had an easier job that day. But, you know, you do, honestly, it's an amazing job that you do. And this is why I'm just like so impressed with the process as well, and the fact that we got a good result. And, you know, it's not just on that particular case. I can just see it working. So I was going to say to you, actually, like, so obviously we're talking really positively about the case that we did together, but are there things that we as lawyers do or don't do that can either be good or cause you a headache?
Yeah, definitely. So I think I've just touched on it briefly then about in a positive way, like you're a prime example of how you dealt with it, in that you were there in a very much supportive advisory role, but you also, you know, you weren't trying to justify your position of being there by trying to intervene and speak for your client or interrupt, or, you know, you actually knew that the power of you being there was to be there in that supportive role and to interject and support the client when he needed you to, but actually it was still very much their, you know, their process in all of this. So I think that can really help if the lawyers just try, and I know it's really difficult because we're just programmed that, you know, when a lot of lawyers, you know, charge by the hour and it's, you know, giving the advice, but actually sometimes just taking that step back and just knowing that the client, knowing that you're there is enough, even if you feel like you've said very little. And actually a lot of the values when you're having those private conversations whilst I'm speaking to the person. So just trying to take a little bit of a back seat and allowing the client the space and time to communicate directly with the conversation mediator. That's really valuable. But we said before, making sure you're really engaged and committed to trying to get a resolution. And so really going into the process with that being the aim. Obviously you want to get your client best result, but also you want to try and secure a resolution for them. And then you talked to Mel about, you know, private FDRs or any FDRs where you're there, you know, and things going well and some momentum. And the beauty of mediation is there's no cut-off point. The courts aren't going to kick you out, you know, at a certain time. literally got, and I can't remember when we finished on hours, but you know, I've gone into 6, 7 p.m. in some cases, because we were making such good progress, and we wanted to secure an outcome there and then. In terms of things that can hinder, I think it's the opposite. So as I say, it's the lawyers speaking too much on behalf of the client, not giving them the chance to respond, not giving them the chance to openly share their views, and even the first things that come into their head. And I know as lawyers sometimes we're thinking, oh God, what's the client going to say? But actually, because it is a private conversation between the three of us, it's really important that they can just comes into the head and speak openly. And it might be that after we do say, should we just have, you know, we could have a private conversation, and that's fine. As I say, not trying to control the process, respecting the process and respecting the mediator's role in all of this, and not trying to, it's not, you know, one shape on, you know, which professional can, you know, speak the most or give the most advice or put forward the woman's argument. Just as I say, trying to understand that actually in the process, you know, the most important in all of this. The mediator's chairing it, and actually, as I said, the lawyers are there very much in a supportive role.
Yeah. I think that's absolutely right, because we as lawyers, you from a litigation perspective, even the ones that are trained mediators, when you sat with the solicitor hat on, I think it's really, really hard to kind of get out of that litigious mode, no matter how much of a nice or fair or reasonable lawyer you are. It's just inbuilt in you to be presenting your client's arguments in the best possible way. So it definitely is, it's a learning curve for us, but a good one, I would say. And I hope that this gives people enough information to use the process, because I just think it's fantastic. And we're on our own timescales then, aren't we? It's like whatever availability you've got and we've got to get an appointment booked in, we're working around that and the client's availability, and not the courts or anyone else's. So it can just be so much quicker and easier.
That's it. The speed and the flexibility of it, I think is a really important part of it, and particularly using that just with the delays of the court. And you know, I'm not going to sit here and say that every hybrid mediation is successful, and unfortunately some of them do break down, and that's not a criticism of the lawyers or the individuals. It's just for whatever reason, unfortunately, they've just not been able to unlock those issues, or that it's not been the right platform for them. But from my perspective as a mediator, if any lawyers have cases where they're thinking, actually, could hybrid work? Could this be a good option moving forward? But just aren't really sure, you know, how it would work and whether the issues are appropriate for a hybrid. I'm always happy to, you know, for a lawyer to give me a call, pick up the phone, and just have a chat confidentially about, you know, the particular type of case that's involved, so we can actually have a conversation about how hybrid might be able to assist, how it would work in practice. The referral process is exactly the same as if it was a traditional mediation, but what I would say is, because I will talk to them about hybrids, but I would say from the lawyer's perspective, maybe just pop a note, you know, on the email that you send, or as I say, you can pick up the phone to me just to say, actually, in this particular case, I'm thinking the actual hybrid model would be a good option, and then I know it's in the forefront of my mind that actually that's what we might be starting with, rather than it being an afterthought. So yeah, normal referral process, but specifically mention that the clients are interested in hybrids. But as I say, I'm always happy to speak to people about the process and the model, and sort of just to try and sound out whether or not it might be a good idea for that particular case.
Well, that's absolutely great.
Yeah.
Well, that's pretty much all I was going to ask you about. Is there anything else that you wanted to ask me about from my version of events process?
No, I think we've covered it actually, Mel. I mean, really what we wanted to get out of this is that we wanted to explain a bit, you know, about the process, about why we see the benefits are, if there are any kind of drawbacks or cases where it might not be appropriate, how solicitors can help and what their role is. Because the only other thing is, in terms of feedback from your clients, you know, what's been the feedback about hybrids? How do you think they found the session?
Well, really, really positive feedback. You know, people have said to me just how invaluable that process was and how reassured, because when they've been in the the typical mediation process. So then they've been dealing with you and having to kind of go through it on their own without that legal support. Yes, they know it's in the background and they can consult us as and when needed, but I think when you're there and there's your physical presence, it can mean a lot to them. So yeah, feedback was really, really good. And they wouldn't hesitate to recommend it. So I accept what you're saying is, you know, I can understand it's not always that case, and perhaps it is client dependent as well, but you know, I would say that process is a lot less stressful than perhaps even going through the mediation process alone, because as a lawyer that's always quite a, you know, a hard thing to encourage your clients to do. You know, go and see the other person. No matter how much we promote mediation as, you know, being this kind of process where they can get a resolution, the fact that they've either got to see the other person on a screen or be in a room with them, it can be a massive put off. But having you there to support them quite often makes them feel more empowered and more ready for that. So
and the other thing I'd say, just as a final point about what you said about, you know, the lawyers and encouraging lawyers to encourage mediation, I suppose the final thought for me is, you know, ultimately it's something that absolutely the lawyers can be fully involved in. And I know sometimes there can be a bit of a disconnect, you know, whether you send your client off to mediation, are you going to get as much feedback as you would like? Are you going to still be able to help manage that process? Well, getting involved in a hybrid mediation, you're absolutely there, you know, from start to finish. And I think that can be some comfort to clients and to their solicitors. And, you know, I've heard solicitors in the past say, oh, it's too complex for mediation, or, you know, it's too high net worth or whatever. Well, there's no really argument for that. No. When a hybrid mediation is can be an hybrid mediation model is available, where actually, as I say, the lawyers feel like they need to be very much at the forefront or a part of that process. Well, they can be with a mediation. And then the beauty of that as well is, even if you don't agree on all the issues in mediation, you've then got the mediator and the lawyers there trying to work out, right, okay, well, maybe we've agreed on some of the issues and we've narrowed, but there are some outstanding issues. So what other alternative dispute resolution process can we engage with now, again, to get a resolution? So rather than the client thinking, oh, it's just broken down, we'll have to start all over again, actually with the lawyers there, they can say, well, maybe we could arbitrate on this final point, or, you know, again, it's just, or we could bring a neutral in. I've worked with barristers before that have been prepared to come into a mediation as a neutral and to give their advice on what they think a relevant legal principle is in that particular case. So it's just got so much scope to focus on resolution, much more than just a traditional mediator client model.
Yeah, I can totally see that. I can really see the benefits to getting someone else in, third party specialist in whether it's a barrister or pensions advisor, or you know, there could be loads of scope, couldn't there? All these issues that we experience on a day-to-day basis that kind of just drum up loads of costs for the client and stress and time, then there is an option to deal with that, isn't there? So yeah, I hope to see more of it, and I hope to get more communications from other lawyers saying, do you fancy giving this a go? Because it is something that I've been suggesting on other cases, and I have to admit actually that it's not, there's the odd lawyer who I've spoken to is up for it, but there's the odd one that isn't at all, and they just kind of rule it out as an expensive or unnecessary process, and they would much rather issue proceedings. But I just think that's, you know, I personally don't think that's the answer. And I hope to see a bit of a shift in lawyers' way of thinking in that respect as well. So
yeah, me too. I'm hopeful that hybrid mediation might become the buzz mediation phrase of 2022. I definitely think that it's going to get a lot of exposure this year. So hopefully this video will go some way to giving it the exposure that it needs. So thank you so much for joining me today, Mel. It's been
no
really
problem. No problem. Lovely to speak to you on this topic as well. As you know, I'm a big fan of it. So thank you. Thanks for having me.
No problem. We'll speak soon.
Speak soon. Bye.
Bye.